Many vendors, SaaS companies, payroll providers, cloud service providers, and even BPOs, they are operating under a very dangerous assumption. And the assumption is that under the DPDPA, they are only a data processor and the liability sits with the data fiduciary. Unfortunately, their assumption is wrong. When most people read the DPDPA, they notice that the law primarily regulates data fiduciary. And naturally, many processors conclude number one, that they don't collect consent, they don't determine purpose, and they merely process data on the instructions of the data fiduciaries. Therefore, if something goes wrong, the liability is on the data fiduciary who would be their customer. This is where the misunderstanding begins. Imagine a situation. A company engages a payroll vendor to process employee data. The payroll vendor stores salary records, bank account details, PAN information, and employee contact details. One day, the vendor suffers a cyber incident. Thousands of employee records are exposed. Now the question is, will the regulators, the affected individuals, and the media simply say that the processor has no responsibility? Of course, they will not. Instead, they will say that the incident happened because the processor mishandled the data. This creates a significant challenge for the in-house legal teams because while the law primarily imposes obligations on data fiduciaries, the operational reality is different. Today, organizations depend on cloud providers, HR platforms, CRM providers, marketing vendors, AI tools, payroll processors. So personal data is constantly moving outside the organizations, which means the biggest privacy risk often sits with the third parties engaged by companies. And here is the most important point that organizations tend to miss. Even if a processor is acting on the instructions, it is still expected to implement security safeguards, comply with contractual safeguards, as well as handle data with responsibility. The moment a processor exceeds instructions, misuses data, fails to implement adequate security measures, shares data improperly, or causes a breach, the conversation quickly shifts from processing to accountability. And that accountability can become contractual, regulatory, financial, and reputational. So the question is not whether DPDPA imposes direct obligations on processors. The more important question is, if the processor causes the problem, who ultimately bears the consequences? In practice, the regulators will look at the data fiduciaries, the data fiduciary will look at the processor, and the processor will look at the contract that they have signed. Suddenly, everyone is discussing liability. So the organizations that are getting this right are not asking whether processors have liability or not. Instead, they are asking, number one, have we conducted a vendor due diligence? Do we have a robust data processing agreements in place? Have we allocated liability appropriately under those contracts, and can we demonstrate adequate oversight over the vendors? Because under the DPDPA, the privacy risk does not disappear just when the data leaves your company, your organization. In many cases, this is exactly where the risk begins.